Okay, folks, I have a joke for you.
What is it?
They're not the folks. Anyway, knock, knock.
Who's there?
The interrupting cow.
The interrupting cow.
Moo! Thank you.
Thank you.
All right. That was an illustration of how not to interrupt somebody when they're talking. What do I mean by that? Well, this video is about the first appearance in court. You never miss a chance to make a good first impression. So how do we appear in court? So as you see, I'm dressed for success. I've got my glasses on. That makes me look smarter. It doesn't make me sound smarter, but I want you to be comfortable in yourself. So I don't want you looking like $1 million. I want you looking respectful to the court. It's all about making a good impression with the court. If I have to make a point, I've got my notes in front of me. They are limited to a card generally. This is for the video, but I've still reduced my notes. And what I want you to learn is you can do a good job at this just by being yourself, but combine yourself with a large element of respect for the court. So here's how we get through a first appearance at court. Generally, you're going there because you've been sued. Once you answer, that kicks off the clerk to send you and the other side a pre-trial notice, generally, where the court wants you to come to court or by Zoom and appear and discuss the case and set the parameters for what's called discovery. So you want to keep these two things in mind. Number one, you want as much open discovery as you can. For example, you want to ask for depositions, so you ask for more than you want. The other side will bark and go, we just want written discovery. You'll hear that. So you've got to argue for your case. A good response to that would be, they want written discovery, but they haven't even written why I owe the debt. There's no paperwork attached to their lawsuit, which is the second part of what your goals are. Discovery and stating your position. But remember, this is not a place to win your case, but just to know it well. First impressions count. I'm wagging my finger at you. Oh, my assistant over here is starting. You will not have a cat at your case. So, first impressions count. I want you to have a position, stick to it, and keep repeating it. Don't, if the judge says, hi, how are you today? Blah, 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 blah. No, you want to be measured and correct and respectful. I guess what I want you to remember is ADHD. We only have 30 seconds or 1 minute at the best because of our phone society to make that first impression and to state our case. So as I will advise you in the other videos that I will be doing on court appearances, such as motions, summary motions, trials possibly, you must front load what you have to say. Meaning, on your card, you're going to take in a little card, and it will say, tell the judge exactly what you want up front. I want discovery. Here's why. The other side has not met its burden of proof. In order to do that, they should show something, Your Honor, where they have proven that they own the debt. Whether I owe the debt is irrelevant, Your Honor, before they have the right and standing to sue me. The way I've looked at it, Your Honor, is standing means that they have proof that they own the debt. There's nothing. In fact, there's nothing attached to the lawsuit. So that's your first part. Refer or show the support of why you should refer to or show the support of why you should win this. Your Honor, if you look at the complaint that they filed, there's nothing attached to it. Or, Your Honor, if you look at the complaint that they filed, it shows clearly that's not owned by them and I don't owe them anything. You're always stating your position. You then will throw in number 3. I will need 90 days of discovery to figure out what they're talking about, Your Honor. She'll give you 60 days, but you always shoot for the stars and she'll give you the moon. everything is negotiating. So if you want 60, ask for 90. If you want 90, ask for 120. The other side's going to bat around their way of doing things too. Keep in mind, a lot of pre-trials, you meet with the other side beforehand. You can be uncomfortable with that, or you can look at it for the best way possible. And that's a chance to settle your case. They will be in a better settling mood. You may have reached out to them before you filed your answer and you got an offer you did not like. That's okay. You'll notice it's reduced. If you did a good job with your answer and your counter affidavit, you will get a better offer. I want you to remember to always bring that counter affidavit that you created everywhere. You did a lot of work on that, hopefully, if you listen to me. That will follow you, as I always say, through every course of action inside a lawsuit, and court appearances and motions, even to trial. That's your blueprint of how to win. So you want to have that next to you. You want a nice book, if you like, of their lawsuit, your answer, your counter affidavit, your counterclaim, any documents that you think are important and tagged for you to instantly refer to. I don't want you to do that. I always counsel when I go to groups and do trial techniques, do not have anything you can rely upon. Because one of the things you're going to tell the jury or even the court, Your Honor, I just saw my brother counsel or sister counsel read from a book to you. I'm going to speak from my heart. So that requires a little bit of work. When you create the counter affidavit, that is that work. It'll be stuck in your brain. You'll remember it and have it there. Have your one piece of paper to rely upon, but reliance should be very weak. If you can maintain eye contact and keep coming from your memory, he or she has 160 cases, all right? They're not going to know the case as well as you by design and because hopefully you listen to me. If you know your case well, that's a chance to make a first impression. This is my assistant right here. If you know their case better than they do, that's a good first impression. You do not go to court in a pretrial to argue your case unless a lot of courts will say, defendant, give me a brief synopsis of what your case is about or what your defense is about. So remember what I said at the beginning. Discovery and state your position. What is your position? Well, you keep it simple, stupid, right? Your Honor, they've not met their burden of proof. They have no documents attached to the lawsuit. There's nothing in that lawsuit that says I owe them a debt because they don't own it. And if you remember the videos I've just recently been doing, not just about plunking, but linchpin. Point to paragraph 5. That's their linchpin. It's another chance to knock out the linchpin and say, look, in paragraph 5, they said the bill of sale proves that they own the debt. Your Honor, if you look at paragraph 5 and the accompanying document, my name's nowhere to be found. In fact, they call their previous owner the predecessor in interest. Your Honor, if they own the debt, wouldn't they know who owned it previous to them? I mean, these are open-ended questions, but you're always stating your position. You're seeking discovery at the pretrial, and you're stating your position. Do not be deterred if the other side starts getting into it with you and blah, blah, blah. I want you to focus. In horse racing, so that the horse has a goal in mind and doesn't deter from that mind, they put blinders on so that the horse cannot see the other horses. So I want you to have your legal blinders on. No matter what, and the other side will bait you and try to mess with you, okay? Just assume that's going to happen. You just stick to your guns, stick to what's important, keep it simple, stupid. You've done your homework. It sucks that you have to do that work, but that's why they call it work. And remember, the harder you work, the luckier you get. It's true. It's great advice. Don't try to win anything at this point. In fact, vulnerability and the ability to look like a victim. I don't like the victim mentality, but if this guy is too much, leave him on his own island, okay? I'm going to give you a quick tip. I have learned after many years of being very emotional because I feel so strongly about my clients and their cases, to not take the bait. Don't take the bait. If you are next to an attorney that's an a-hole and starts acting like an a-hole, and you hear things you don't like, so you start interrupting and stopping him from saying the lies that he's saying, the judge does not say, oh, there's a reasonable person, there's an a-hole. The judge just sees two a-holes. So do not take the bait, okay? Because you've got your legal blinders on. I should have started this at the beginning, but this is more appropriate. Have legal blinders on. Be a robot. Attached to this video will be the top 10 tips that I give you, and there's a video on that. There's also a video, let me refer to the linchpin video and the plunking video, and also more importantly, the counter affidavit. That is so important. I even have an ebook on appearing in court. There is no better way to make a first impression with the court than to stick to your guns, be extremely respectful, wear something that says, I know I'm not seeking $1 million and I can't afford all these great suits, but I wanted to dress the best I had for you, Your Honor. I don't know if I own a suit that is more than $300 or $400. And when I'm in trial, I sometimes wear my worst suits because I want to sit next to my client and I'm not showboating and we're in the same place here. Generally, it's against attorneys there's 2 or 3 attorneys, big suits, big money. I don't like to be that guy. It's a bad impression. You're all about making a first impression. So the takeaways from this video are stick to your guns, stick to your position, have a position, front load everything you need the court to know at the very 30 seconds to a minute, and keep repeating that. Do not interrupt the other side. Do not interrupt the court because they'll bait you and say something that's totally false. You'll start arguing. The court will have to step in. Now you're an a-hole. The more calm and respectful you are, the bigger a-hole the other side looks. Here's a little quick pro tip. I hope you remember this. Write it down. My show notes accompanying this video will go into greater depth of how I want you to prepare for the next or first court appearance. But I want you to keep referring to the other side as the debt collector. Not Mr. Smith, not Miss Smith, not the law firm, not where they're from. The debt collector. Every time you talk about the other side, the debt collector. In fact, I'd write down on my little card that I bring, make sure you say he's a debt collector at least 3 or 4 times. Keep referring to the debt. Have you had a chance to talk, the court will say, you have a chance to talk with Miss Smith? Miss Smith, Your Honor? Oh, the debt collector? No, I have not. I could talk to the debt collector now if you'd like. I'm pretty much certain that they're not going to have the documents. They would have had it by now. As you know, Your Honor, they have not proved or shown the burden of producing something, anything that shows they own the debt. This is just another one of thousands of cases they have. And I want to repeat to the court that my counter affidavit fully breaks down how they have not met their burden of proof and how I don't owe this debt to this debt collector. Again, check out my membership website. Check out the show notes accompanying this video. Check out my top 10 tips that are attached to this video. You may want to look at my ebook or look at all those other videos. And that's how you make a good first impression on your first appearance with the court. Thank you.